State of Wisconsin versus Terry Nolan, 20 CF 1359. Appearances, please.
Jim Griffin for the state.
Mike Placid is here on behalf of Terry Nolan, who appears in person. Good morning, Mike.
Good morning. Mr. Nolan, welcome to you, sir, and to the attorneys. Counsel, what would you wish done both in this matter?
Your Honor, hopefully, we were here last week, and Mr. Nolan had a bit of confusion getting through the elements and the other aspects that Your Honor was going through him as far as the facts of the case are concerned. I've talked to him since then, and I think he'll be able to get through the plea, Your Honor. If he's able to do that, then we want to go to sentence.
All right. If there could be a statement, if the attorneys had discussions as to what would be recommended, could that be of record, please?
Judge, it's my understanding the defendant will plead guilty to the charge in the information. At sentencing, the state will be recommending prison.
And defense plead argue?
Yes, sir.
Ms. Place, is that accurate?
That's right.
All right, Mr. Nolan, I'm going to ask you a series of questions. If there's anything you don't understand, tell me. We'll stop and you'll be able to talk privately with your attorney. Understand?
Yeah.
All right. In this matter, you're charged with one count of being a party to the crime of armed robbery. Have you read the underlying criminal complaint and information?
Yeah.
Right. I'm required to review with you the maximum sentence that could be imposed, and that is a fine of up to $100,000 and prison incarceration of 40 years divided between a period of initial confinement in prison and a period of extended supervision. Do you understand those are the maximums that can occur?
Yeah.
Next, the burden is on the state to prove each element of this crime beyond a reasonable doubt. Counsel, thank you for submitting the sheet. Here, the state must show that you took property from the person or presence of the person who is the owner of the property. Do you understand that element?
Yeah.
Next, they must show that you took that property with an intent to steal. You understand that?
Yeah.
Third, they must show that you acted forcibly. You understand that?
Yeah.
The fourth element is that at the time of the taking and carrying away of the property, you used or threatened to use a dangerous weapon. You understand that element?
Yeah.
All right, we've gone through the elements now and the maximum penalty. I now do ask with respect to the single charge of being a party to the crime of armed robbery, what is your plea to that charge?
Yeah.
Are the facts contained in the underlying criminal complaint relating to what happened, are those facts accurate?
Right.
Are the facts contained in the criminal complaint relating to the crime of being a party to the offense of armed robbery, are those facts true and correct? Pardon? And I got it wrong. In this case, there's a criminal complaint, and in the complaint, it lists various facts as to what occurred. Are those facts relating to the crime of armed robbery, are those facts correct?
Yeah.
Is anyone forcing you or making you admit to this crime?
No.
Are you pleading guilty of your own free will?
No.
When you enter this plea, you give up your right to a trial by jury where the verdict or decision of the jury must be unanimous. Do you understand you're giving up that right?
No.
You also have a right to remain silent. No adverse or negative inference can occur when you do remain silent. And if you were to go to trial and remain silent, your attorney could still call witnesses if you wished, and your attorney would have a right to cross-examine anyone who testified on behalf of the state. You are giving up these rights. Do you understand that?
Yeah.
Next, the burden is on the state to prove your guilt if they can, beyond a reasonable doubt. In this case, however, you've told me as to this single crime that you're guilty. You've told me also that the facts in the criminal complaint are accurate and true. I want you to understand that that would provide a basis for me to conclude beyond a reasonable doubt that you're guilty. Do you understand that?
Yeah.
On your behalf, Mr. Placid has submitted a plea questionnaire and waiver of rights form, as well as an addendum. And they purport to have your signature on the 5th of August. Have you read these documents?
Yeah.
You have any question about them?
No.
Is the data that's been written into the forms true? In the form, various information has been written in. Is that information true?
Yeah.
For instance, sir, it says as to your age that you're 59. Is that true?
Yeah.
It also indicates that you've completed, in terms of schooling, the 7th grade. Is that true?
Yeah.
As a result, you do not have a high school diploma. Is that correct?
Right.
Have you understood fully everything that's occurred here in your case this morning?
Yeah.
The form indicates as well that you are currently receiving treatment for a mental illness or disorder. Is that true?
Yeah.
Do you know what the diagnosis is in terms of that mental illness or disorder? Pardon?
Schizoaffective, I think he's saying, Your Honor.
Okay, thank you. I didn't hear it.
There was a competency exam in this case, Your Honor. And I'm not seeing a diagnosis. But he is on Social Security disability.
All right, thank you. And is that accurate, Mr. Nolan?
Yeah.
The form also indicates that in the last 24 hours you have had, it says alcohol, medication, or drugs, and I assume it means medication. What medications have you had, sir, in the last 24 hours?
Everyday man.
Everyday meds.
Yeah.
How many different medicines do you take every day, sir?
About 6, 7. Yeah.
Okay. Do you know the names of those approximately 7 medications, sir?
No.
How long have you been taking a roughly 7 medicines a day?
Been a while.
Has it been over a year?
Yeah.
And when you take those medicines, do they help you to get through each day in a positive way?
Yeah.
All right. On the plea phase and only the plea phase, is there anything more either attorney wishes in the record? First District Attorney,
No, sir.
Mr. Placehead.
No, Your Honor.
All right, in this matter, Mr. Nolan, I make 2 findings in your case. First, I find that your plea of guilty to the single charge of being a party to the crime of armed robbery is a plea that you've entered freely, knowingly, and voluntarily. You've told me that and I accept it. The second finding I make is based on the entire record, not just your plea of guilty, but also the data contained in the underlying criminal complaint, as well as your answers as given to questions posed. I find that your guilt to this single crime has been established beyond a reasonable doubt, and I do find that you are guilty as charged of being a party to the crime of armed robbery. Now, consistent with the statements made earlier in terms of proceeding on, do the parties wish to proceed on to sentencing?
Yes.
All right, District Attorney, I need to ask a question in terms of any notification of victims. Has that occurred?
It did, Judge. We notified the people at 7-11.
All right, let me take just half a minute.
There has been no request for restitution, so restitution should be set at 0.
All right, we'll proceed then to sentencing. I'll look to the parties, beginning first with the State District Attorney.
It's a knife armed robbery. The defendant asks for cigarettes. The clerk M stated when he went to grab a couple more packs, when the defendant asked him for the other packs and Ben looked up, the defendant had a knife and was starting to extend it over the counter towards him. So he jumps back and the defendant then grabs 2 packs of cigarettes from the counter and leaves. Again, 2 packs of cigarettes for a 40-year felony, not a good calculation by the defendant. And, you know, M jumps back because he has no idea what the defendant is going to do with that knife. I understand the defendant may say, I never meant to hurt him, or, you know, I was just trying to scare him, but like everything else, whether the gun is empty or the knife is going to be used, it really doesn't matter to the victim who has to go through this. And I would say that Mr. Nolan's level of caring about that victim was 0. He, of course, admits and semi-denies in a weird way, similar sort of to what he did the other day here, but ultimately he has pled guilty and deserves credit for that. His record here starts in 2019, with the disorderly conduct. He got 27 days time served. There was another in 2019, 2 counts, battery and disorderly conduct. He was given 6 months in the house on the battery and placed on probation for the disorderly conduct count. There was another case that was a bail jumping that was dismissed and read in 2019. We did not run an NCIC on him, but if Mr. Nolan has lived outside of Wisconsin, I do find it odd that his criminal activity would start at age 58. But unfortunately, I don't have any information one way or the other, so I'm not asking the court to sort of assume or infer, other than maybe to ask Mr. Nolan about his record, if he has one, anywhere else. But again, when you pull a knife on a clerk in a store who's just at 7-Eleven, what's he getting, $10 an hour, 9? And we have to go through this, it's just uncalled for. And so that's why the state is asking to send Mr. Nolan to prison at his age and for what he did. Thank you.
Sir, thank you. Next, Attorney Plaisted.
Thank you, Your Honor. I think the competency exam is helpful in terms of his background. Mr. Nolan is chronically homeless. He does have a payee through Community Advocates. And he would have to get back in touch with them to start his SSI again. As you know, that's not available while people are incarcerated. So he's going to have to get that back on track. He knows where to go for that at Community Advocates. And he also knows where to go for his medication that he needs to stay stable in the community. There is a co-defendant in this case. The co-defendant is in a different court. Now Judge Borowski's court. He's scheduled for a plea on September 21st, I think. I looked at CCAP. That's what it looked like. Although Mr. Nolan is the one who came in to the store with the purpose of stealing cigarettes with this knife that Mr. Smith gave to him to go in and do this. Mr. Nolan was intoxicated at the time. Smith didn't want to put himself on the line as being the person that came in and did this. Mr. Nolan was nervous. He didn't want to do it. He appears nervous in the store on the video, although he's got a big hoodie up. It's March and it looks like it's cold out. Hooded jacket. So you can't see his face, but he was nervous as he asked this clerk for cigarettes. He says, I don't think it makes that much of a difference, that he asked for and got 1 pack of cigarettes. The 2 were confronted right outside the store, also on video, and 1 pack of cigarettes was found on Mr. Smith. The knife was also found on Mr. Smith. When Mr. Nolan came out of the store, he gave the knife back to Smith, gave the cigarettes to Smith, and Smith said, well, we'll just sell these on the street. We'll sell loose cigarettes on the street. And that was Smith's scheme to make a little money and put Terry at risk by being the one who walked into the store. On the other hand, Terry Nolan is old enough, he should know better, but he's vulnerable at the time, not only because of his mental illness, but also because he was intoxicated. So I don't think this is a prison case. It's not a gun, it's a knife. The actions in the store, he puts his hand over the counter as the clerk goes into the drawer for some more cigarettes, and then immediately, as soon as the clerk reacts, he leaves the store and walks away. They can go very far. He meets Smith outside, gives him the cigarettes, gives him a knife, and he doesn't appreciate that Mr. Smith got him into this circumstance. On the other hand, he had a free will not to do it. And I don't know what's going to happen to Mr. Jimmy Smith. So I don't think it's a prison case. Perhaps Mr. Nolan would benefit from some sort of probation. Even if there is probation, I don't think it's an imposed state prison sentence is necessary in this case. I think the nature of the offense, armed robbery, is serious, the 40-year maximum, as Your Honor pointed out. But I don't think even if he fails on probation, the prison time is necessary. I submitted a credit form, Your Honor, I believe it's 137 days that he sat, if that's accurate on the form. I'd actually give him credit for that, and then he imposed a state sentence. Well, Mr. Nolan is vulnerable himself, and Mr. Smith took advantage of that so that he could get cigarettes that he could sell. And Mr. Nolan would have gotten, if they completed it the other way, would have gotten absolutely nothing out of this. This is all directed by, the knife was provided by, and the cigarettes were taken by Kobe. So I guess you take all that into account. I know there's a general deterrence argument that any armed robbery of whatever sort, whatever nature, should have a prison sentence. I don't think in this case, given the nature of the threat that was made and the nature of Mr. Nolan and the vulnerable nature he was in at the time, makes that necessary. Your Honor. I ask that you put him on probation for a couple of years, and if you do, I ask that you refer him to the mental health unit. Drinking certainly isn't good when he's supposed to be on medication, but probably didn't help the situation that he was intoxicated at the time, plus his medication, if he was taking medication at the time. So there's numerous probationary needs that Mr. Nolan has, and I think they can be provided. Thank you.
Sir, thank you for your comments. Is there anything you wish to say, Mr. Nolan?
Well, he was there, oh, he was there, he was putting up the door, and I was under direction. I think he did want to do it, but he got the pressure on. I can't even watch down it, and then do it. And I felt like, well, those also, that's not back up. I feel he was like, fine.
I'm sorry, I missed that last part.
After that, he was fighting. And so I backed up and then I went outside the store. And after the dude walked up to me and how much he could do. I thought, I got it back to him. Because I know we can start to see each other. And we got like 2 blocks away.
All right, I take the statement you made into consideration, but I have some questions. Are you now married?
You know,
Do you have any children in the world where you're the birth father? Your attorneys pointed out that you're receiving or did receive before you went to jail, Social Security disability. Is that true?
Yeah, that's true.
How long have you been receiving Social Security?
And, we opened up 2013.
2013?
Yeah.
Thank you. Prior to 2013, what type of work did you do?
I was spray painting.
Spray painting? I looked at the report on competency from Dr. Pankowitz dated 14 April of 2020. It indicates there's a history of abuse of chemicals, including alcohol. Is that correct?
Yes.
Other than the crimes noted by the district attorney, there was 2 disorderly conducts in 2019 and then a battery. Do you have any other record of convictions for crime anywhere?
No.
All right, sir, thank you, and to the attorneys. In this case, you're to be sentenced for the crime of party to armed robbery, 40 years or the maximum, plus the potential for a fine of up to $100,000. You're 59 years of age, still a young man. You do have a prior record, again, the 2 disorderly conducts in 2019, as well as a battery. You had time in the House of Corrections as well as probation. Your education is a 7th grade. and I accept that, but you've understood the proceedings that are before us now. The doctor also indicated that you were competent to proceed, and I accept that. You're not married, you have no children. When you were younger and were working prior to the year 2013, the type of work you did was apparently in the painting field. You worked as a spray painter. But in 2013, you received Social Security disability. What was the disability for, sir?
Bipolar, different vector, in the back, lower spine of that. I can't hear that.
Council,
Sure, he said bipolar schizoaffective
okay.
and a back issue. He said there was a back issue.
All right, is that correct, sir?
Yeah.
All right, thank you. The report from Dr. Pankowitz indicates as well that you've had mental health treatment in the state of Illinois. Again, a history of abuse of both alcohol and chemicals. Now, the offense here is certainly one that relates to property in terms of the armed robbery, but it affects another person, the person who is the victim on the other side of that knife. Aggravated because it is serious. Sometimes people in stores have guns and you could have been hurt if there was, but the other person could have been hurt or feared that he would be hurt. Offense therefore is aggravated and you're fully responsible for it. The fact that you're 59 doesn't diminish the responsibility that attaches to the seriousness of the crime. You are fully culpable or responsible for the offense. Now, the public has a right to be safe. That includes you and the people you love and care about, but it includes everyone else. And it certainly includes the victim here. Your rehabilitation needs are not something we just list on a sheet of paper, but they must be addressed in a sentence that's imposed. I also must consider the gravity of the offense. Given all the foregoing, what I'm going to do is the structure is an imposed and stayed sentence and then probation. I think that's fair in the context of this case. In particular, 59, no past record other than the 3 misdemeanors that were noted, and they were at age 58. I think also the appropriateness of, in terms of your rehabilitation of providing certain services for you can benefit you and the safety of the community. Given all the foregoing, I'm going to order as follows. First, it's the order of the court you be committed to the Department of Corrections in the state of Wisconsin for a period of 2 years initial confinement. That's to be followed by a period of 2 years extended supervision. You're to get credit for 137 days already served. That sentence now imposed is stayed. In lieu thereof, you're to be placed on 2 years of probation. Before I go further, I want to mention something. I want you to succeed on probation, but you will not succeed as an accident. You'll succeed as a result of your own effort. More people in Wisconsin, as I understand it, go to prison as a result of revocation than go to prison as a result of a judge somewhere saying you're to go to prison, say, for 2 years. I don't want your probation to be revoked. But many, many people have their probation revoked if you don't follow the terms and conditions. I'm going to establish certain terms and conditions. The idea is to provide some structure, but help for you, but also safety for the community. Now, those terms and conditions are first, restitution is set at 0. You understand that? I'm not imposing any fine. I don't find you have an ability to pay. However, you must pay the court costs associated with this matter and any mandatory surcharges. I can't waive those. Now, today is the 13th of August. I'm going to order is on the 13th of December and the 13th of each month thereafter, you're to pay $25 toward those court costs and mandatory surcharges until that's paid in full. I'm providing a period of time here so you can get out of jail, not into a job, but so you can reestablish yourself, as your attorney pointed out, with respect to Social Security. And then that amount is to be paid each month until it's paid in full. Do you understand that? Counseling is to occur as the agent would deem appropriate. If there are specific counseling needs, certainly in the alcohol and drug assessment, if there's any recommendations for follow through, that's to occur, and there's to be a review in terms of to monitor that you do not use alcohol or any controlled substance during your probation. They can use random UAs or other means to monitor your compliance. I don't want you to fail, but you must comply with that. You understand what I just said?
Yes, ma'am.
And you're not using alcohol or any controlled substance. A DNA specimen is to be provided since you've now been convicted of a felony. You may not vote until your civil liberties have been restored. You may never possess a firearm ever. You understand that?
Yes, ma'am.
What did I just say about a firearm?
No, this is not, this is good. Bye.
Now, wherever you live, there may be other people living there, but you cannot even live with someone who has a legitimate right to possess a firearm. You would have to leave. You understand that?
Yes, ma'am.
And again, I don't want you to fail, but that's a big one in terms of people being revoked. Another big one is using alcohol or controlled substances. Are you able to comply with those conditions?
Yes, ma'am.
You're not to have any contact with the victim, and in the form, it's in the plan, it's listed as MMM. And the store was,
7-Eleven?
and you're not to have contact with any 7-Eleven store. Do you understand that?
Yes, ma'am.
Now, the other person involved was a person named Jim or James Smith. You're not to have any contact with that person. Do you understand that?
Yeah.
Now, if that person reaches out to you or someone else reaches out on his behalf, you still can't be in contact with that person. Do you understand that?
Yes, ma'am.
Any other special programs that I may not be aware of that would exist here in Milwaukee to help Mr. Nolan, First District Attorney?
No, sir.
Same, Mr. Plaisted?
I think Your Honor can recommend that he be assigned to the mental health unit. And I think that's helpful to have specialized agents there to deal with people with mental health.
We'll follow that, and thank you. You're also to be under these conditions of supervision or to be assigned to the mental health unit, and then hopefully you'll receive services that uniquely are available through that department within the Department of Corrections. Madam Clerk, is there anything else we have to impose here? All right. Mr. Nolan, are there any of the conditions I've just established that you feel you could not comply with?
No, ma'am.
Again,
Programming if he's revoked.
you want any special programming eligibility if your client is revoked?
Earned release, if that's possible, if he gets into treatment in the institution.
Right? If revocation occurs, and I hope it doesn't, he's to be eligible for that earned release program and any other programs that would be appropriate given his age as well. All right. Good luck to you, sir.
I'm going to give you some information here. There's a phone number on one of them.